861 words, within the 855-945 target range. Here's the finished script. There is a legal doctrine called qualified immunity. It appears in no statute Congress ever passed, and it has shielded government officials from consequence since 1967, the year the Supreme Court invented it in a case called Pierson v. Ray. No vote, no bill, no public hearing. By the time this ends, you will understand why the people with the most power over your body and your rights are often the people you can never sue. Here is what it actually is, in plain terms. Qualified immunity is a rule that says a government official, a police officer, a prison guard, a caseworker, cannot be personally sued for violating your constitutional rights unless a prior court case with nearly identical facts already declared that exact conduct illegal. Not similar, nearly identical. If no case matches closely enough, the violation is legally invisible. It happened. You felt it. But in the eyes of federal law, it does not count. This did not come from the Constitution. It does not come from Section 1983, the actual 1871 civil rights law that lets citizens sue officials for violating their rights. Congress wrote that statute to say the opposite, that any official acting under government authority who deprives someone of their rights shall be liable. No exceptions. No immunity clause. The Supreme Court added qualified immunity 96 years later, reasoning that officials needed protection from lawsuits so they could do their jobs without fear. Then in 1982, in Harlow v. Fitzgerald, the court rewrote the test again, replacing questions about an official's actual intent with the clearly established law standard, a standard the justices themselves designed and can redefine at will. So who controls it now? Not Congress, not voters. Federal appellate judges, ruling case by case, decide what counts as clearly established. And because the standard requires a near-identical prior case, courts frequently rule that no such case exists, which means the current case can never become the precedent either, since the judge dismissed it before reaching the merits. The doctrine protects itself from ever generating the evidence that would end it. Here is what that means for an ordinary person. In 2014, a Fresno police officer allegedly stole over $200,000 in cash and coins while executing a search warrant. The family sued. The Ninth Circuit ruled in 2019 that the officers were protected by qualified immunity, not because stealing wasn't wrong, but because no prior case had specifically established that officers stealing property already seized under a warrant violated the Fourth Amendment. The theft itself was never disputed. What was disputed was whether it had been illegal enough in a legally recognized way before that specific day. It hadn't been, so there was no remedy. Remember, no one voted for this test. No legislature debated how specific a prior case needs to be before a citizen can collect damages. A handful of judges built that threshold, case by case, and every citizen since has been measured against it without ever being asked. Multiply that logic across tens of thousands of cases a year, excessive force, wrongful death, unlawful detention, and you get a system where the violation can be real, documented, admitted, and still produce zero accountability because the paperwork of precedent hadn't caught up yet. And here is the part that should actually worry you: it's completely legal. Every step followed proper procedure. Judges applied the doctrine exactly as designed. Nothing was hidden, nothing was broken. The system worked precisely as intended, and that is the entire problem. It cannot be repealed the way a law can, because it isn't a law. Congress could pass a statute abolishing it tomorrow. Bills have been introduced repeatedly since 2020 and gone nowhere, because the officials who benefit from the doctrine lobby against removing it, and few legislators want to be blamed for handcuffing police. The Supreme Court could also overturn its own precedent, but it has repeatedly declined to revisit the doctrine's foundation, even while individual justices across the ideological spectrum have publicly questioned whether it was ever legitimate. So it sits in a gap no single vote can close, too judicial for Congress to easily touch, too entrenched for the court to unwind, sustained by inertia on both sides of the separation of powers. Think about what that structure reveals about every other doctrine you've never heard of. If a rule this consequential, deciding whether you can hold the government accountable at all, can exist with no statute, no ballot, and no repeal mechanism, then the architecture of American law contains rooms nobody built and nobody can enter to tear down. Judicial doctrines like this don't announce themselves. They accumulate quietly through case law, cited forward for decades, until reversing them would mean unwinding thousands of settled rulings, every one of which now depends on the last one being correct. So the question is not whether qualified immunity will change. It's how many other doctrines like it are sitting in the same gap right now, invisible, self-reinforcing, and waiting for someone to notice. Save to home /jarvisadmin/script hidden rule qualified immunity, txt.